Next, let us look at the mental elements in tortious liability. We know that in a tort, there is a wrongful act, which can be a malfeasance, a misfeasance, or a non-feasance. In some cases, to successfully prove a tort, or as a defense against a claim of tort, the mental status of the person who is committing the breach of duty has to be taken into consideration. In some torts, like a battery, assault, or trespass, the accuser may need to prove that the act was committed intentionally. For example, if I'm just following Google Maps and I drive into somebody's private road, it was not intentional, so it may not be a tort. If I know that it is somebody's private property and I still drove into that road, then it is intentional. Negligence is a situation where the wrongful act occurred unintentionally, but because the person failed to exercise due care. Many accidents occur because of negligence, because the driver may be distracted by something inside or outside the car and fails to pay attention to the road ahead. So, due care was not exercised. Recklessness or rashness is where a person knows that acting in a particular way is risky, but still does that. Driving on the wrong side of a highway is a known risk. So, intentionally driving on the wrong side is reckless or rash behavior. Malice is where a person commits a wrongful act due to ill will or an improper motive. Suppose two persons have previously had a fight and don't like each other, and one of the persons intentionally goes and damages the other person's property. Because of that feeling of dislike or anger, then the wrongful act has been committed out of malice. Malice in fact is where an actual malice is apparent, such as the history between the two persons in our example. Malice in law is where the courts will look at the circumstances and presume that malice exists, even if it is not apparent. Then there is strict liability, such as in the Rylands versus Fletcher case, where the defendant may have taken reasonable precautions and not acted negligently, but is still liable for the damages. However, in strict liability, there are still some exceptions, such as an unpredictable earthquake or a storm, which are acts of God, or if the damage was caused due to the plaintiff's own fault. The strictest form of strict liability is absolute liability, which was laid down in the oleum gas leak case, where there are no exceptions whatsoever, even if all due care is taken and the damage was done due to an act of God. The defendant will still be liable.